mentally ill of count 1, the lesser included offense of reckless homicide, count 2, attempted murder, count 3, the lesser included offense of criminal recklessness, count 4, lesser included offense of criminal recklessness, count 5, lesser included offense of criminal recklessness, and count 6, criminal confinement as a level 3 felony. The court ordered a pre-sentence report, and Ms. Casanova, have you and your client had a chance to review the pre-sentence?
Yes, Judge.
Are there additions or corrections to it? Is the credit time correct?
Yes.
Okay. And then state, have you had a chance to review the pre-sentence report?
Yes, Judge.
And are there additions or corrections from the state of Indiana?
No.
All right, the court also did have an opportunity to read the defendant's sentencing memorandum that was submitted in advance in court. So the court has reviewed that. Just for the record, we show he has 1,457 days currently in custody with 486 days of good time credit under Indiana law. Everybody agree?
Yes, Judge.
Yes, Judge.
Okay. All right. So with that, then, does the defense have evidence which you wish the court to consider in addition to your sentencing memorandum?
Yes, Judge.
All right, you may call yours.
Judge, defense calls Larry Dorsey, Sr.
Sir, can you raise your hand for me? Promise what you're about to tell the court will be the truth, the whole truth, nothing but truth, under pain and penalty of perjury.
Yes.
All right, please be seated. Once you're comfortable in your chair, can you tell me who you are and how you spell your name?
My name's Larry Dorsey Sr., Larrydorcy.
All right, thank you, sir. Mr. Casanova?
Mr. Dorsey, could you remind the court again what your relationship is to Elliahs Dorsey?
Elliahs Dorsey is my son.
How many other sons do you have?
I have 2 more.
And what's the name of your oldest son?
Larry Dorsey Jr.,
And your youngest son?
Deontay Dorsey.
And is
Is your wife here for you all?
Yes.
And what's her?
Shalice Marie Dorsey.
And how long have the two of you been married?
It'll be, June will be 40.
40 years.
Yeah.
And prior to this incident, had any of your sons ever been arrested?
No.
Where did Elliahs attend middle school?
He went to middle school at Shortridge Junior High.
Did he ever attend IPS?
Yes, IPS 14 was his elementary school.
And I'm going to show you what I've now marked for identification today.
Do you recognize that?
Yes.
And what do you recognize that as?
That's his, I believe that'll be his 2nd grade picture or at 14.
At IPS?
At IPS School 14.
Okay, and is that a fair and accurate representation?
Yes.
Okay. Judge moves to admit and publish.
The objection to defense A? We shall A admitted without objection. And when Elliahs was at IPS 14, were you familiar with the name of this principal?
Yes.
And what's her name?
Miss Odle.
And are you also familiar with one teacher, assistant?
Yes, Miss Bishop.
Did you have contact with both of those teachers when Elliahs was at IPS 14?
Yes.
As well as your wife?
Yes.
And how would you describe Elliahs' relationship to the rest of the kids in his class at IPS 14?
He probably was more like the leader, one of the leaders of the class. So they would look up to him.
Can you give the court any examples of way in which Elliahs acted as a leader?
Yeah. One thing that comes to mind is when they switched over to uniforms, and Elias protested. He did not want to wear the uniforms. So Miss Odell called. We had a conference, talked to Elias, had to convince him if he wore the uniforms, the other kids would wear the uniforms. So they eventually convinced him to wear the uniform because he just wanted to, like, we should be able to wear regular clothes. But he ended up wearing the uniform, and then everybody else fell in place.
And again, was that kind of typical of Elias' relationship with his classmates?
Yeah, yeah.
And now, did you participate or were you involved in coaching youth teams?
Yes.
And how long have you been involved in that?
It's been over 30 years.
And do those youth leagues include leagues associated with that?
Yes, yes. With PAL for about 20 years.
And can you briefly explain what PAL is?
PAL is a city program to mentor the youth, have sort of like back in the day where they had officer friendly, where they showed the police are not bad. So they would offer programs, give them a place, a safe haven to go to.
And I'm going to show you now what I've marked for identification as Defendant Exhibit E.
Do you recognize that?
Yes, I do.
And what do you recognize that as?
That is, we just my team and the PAL team. PAL had like their own inter squad team also. We all scrimmaged together, and then this was a cool down where the coaches and the officers, we all would talk to the players.
Okay. And is that a fair and accurate representation of what happened on the day that photo was taken?
Yes, it is.
Move to admit defendant, please.
And in this photo, do you recognize any police officers in the photo?
Yeah, I see one right now that's standing there. He's got the PAL shirt on. Look like he's on his phone texting.
That's a touch screen.
He's right here.
Was Elias also present?
Yes, he was.
Can you go ahead and circle where he's at? How old was Elias when he began working as a coach?
He started when he was like 13.
And how long did he continue doing that?
He done it all the way up till COVID.
So he was involved in assisting and coaching the youth leagues basically up until his arrest.
Yes,
And would that include leagues associated with PAL?
yes.
And I'm assuming you had a number of opportunities to observe Elias's interaction with other coaches and participants in the youth league, including PAL teams.
Yes.
Did you ever observe any animosity between Elias and any police officers?
No, there was never any of that. We always done a lot of joking, and um, maybe shooting basketball or throwing the football around or something like that. But no, none of that. It was always great relationships.
Can you explain a little bit of how youth leagues, including PAL, got involved with the communities where you were coaching teams?
We'll host like community days where they'll have like free food giveaways, or they'll do, put a jungle gym or bounce house out and invite the community just to get the community to know the police officers, fire department will show up.
And can you explain to the court what you personally did to encourage
Oh, I personally would go around and see a kid that might have wanted to play, or you used to be able to just find them outside playing. Now you don't see a lot of that, but they'll be outside playing, throwing the football. So I would go get them, see if they want to play. They'd be like, "Yeah, I want to play." It costs X amount of dollars, but we didn't worry about that. We personally fund the kids, get them in the uniforms, get them out, so they'll be able to take and have a safe haven to go to. And by the time they got done there, got home, took a bath, ate, they would go to bed.
Did you mentioned, would you be involved in paying for entry
Oh yeah, oh a lot of times. I done paid the whole team entry fees. I just wanted the kid to be able to go out and at least enjoy yourself and not let money be an issue, and still do that.
Would you also be involved in
And
transporting?
transporting them to and from, picking them up from their house, going to talk to the teachers, trying to make sure they keep their GPAs up. Yeah.
And would you also assist in getting them food?
Oh yeah, yeah. We go to sometimes take them to McDonald's. We'll go get pizzas. You know, some go to a pantry, get parents some food for them to take home. So
And I mean, is this similar to what you did for your boys growing up to keep them out of trouble?
yeah, yeah. It's just something that I started in the neighborhood and just kept it going.
And as you observed Elias being involved in the youth leagues and coaching teams, did you see him do the same things?
Oh yeah, he pretty much just seen what I was doing and picked up that same habit. And so he would take guys to take the kids to go get haircuts, take them to get eat. If a family was out there on the corner and needed some food, he would take them in a restaurant, buy them something to eat. You know.
I'm going to show you now what's been marked for identification as Defendant's Exhibit C. Do you recognize that?
Yes, I do.
And what do you recognize that as?
That's a coaching plaque for his dedication and hard work with the Squires.
And who is the person that is being dedicated to?
That's dedicated to Elliahs Dorsey.
Okay. Move to admit defendants to the public.
Trustee admitted without objection. Page number.
So can you, the Squires, can you tell the court a little bit who the Squires were?
The Squires was our 11 and 12-year-old. Well, actually, they were 11 and 12 at that time. Year old football team that was part of PAL. Um, they were, Arlington was the Knights. Knights have the Squires, so they were the younger version of the Knights. Elias was Arlington Knight, so he would help mentor the Squires.
And was this going on while he was in high school?
Yes, while he was in high school, he would go to football practice, and then after football practice, he would go help coach the Squires.
And essentially, I mean, what was he doing with the Squires similar to the things that you described you had done?
Yes, the same thing I would do. He would also, of course, teach them the techniques and their positions. But yeah, he would get them food, mentor them, make sure they get their grades together.
And basically, the plaque depicted in Defendant C, is that basically an
An
acknowledgement?
acknowledgement of his hard work and his dedication to the youth team.
Um, I'd like to talk a little bit now about the contact you've had with Elias since this incident.
Okay.
Have you been in contact with him while he's been?
Oh yes, every chance we get, every night, as long as the systems at the prisons are working, we'll talk.
And what have you been encouraging him to do?
keep his head focused. Just keep him encouraged. To try to stay away from any incidents. Just to stay positive.
Have you been encouraging him not to get into disciplinary?
No disciplinary action, none of that. And also try to encourage the people around you. That way you don't, they'll look up to him because a lot of them are younger than him. So
You've also been encouraging him to not get into
any type of incidents with staff or anybody like that.
And I assume that's something you will continue to do.
Yes.
Have you, what is one of your primary concerns in terms of any type of sentence lawsuits in this case?
Treatment.
When you say
Treatment. Them finding just giving them some treatment for the mental health that he has.
And can you also talk about, well, is it fair to say you kind of purposely avoided talking to him about the facts of the case?
Yeah.
Has he ever expressed to you remorse for it?
Yes. All the time. Since well, I ain't gonna say it. Once he realized what happened after several days, then he's been remorseful all the time. I mean, it puts him into a dungeon, and I have to try to pull him up and try to keep his head high while he's in there. So
Can you explain a little bit more about what you just said, his remorse and that?
it puts him down, gets him really down. He's just like he just can't believe that he done something like this.
I don't believe I have any further questions.
Thank you, Ross.
No questions, Judge.
Dad, how much, if any, of the time that you were talking to him while he's been incarcerated pre-trial, how much time do you think you spent talking about that he was looking potentially at the death penalty?
We talked about that quite a bit. Yeah, I mean, 50%, 60% of the time we would talk about it and then try to go into something else.
Okay. I know were you present when the doctors testified? And if you weren't present, you may not have been physically present. Were you able to hear the doctor's testimony?
Yes, I was.
Okay. All right. I assume you probably monitored it from home.
Yeah,
Okay,
yes.
I figured as much. One of the concerns the court had was the doctors talking about the defendant still believing that in his paranoia that the police were coming to get him that night, and that he had changed that focus. Did you talk with him at all about that, or was that because it was close to the facts of the case? Was that something you?
It was too close.
Okay, fair. That's fair enough. All right. Since the trial, have you had a chance to talk with him about his need for mental health treatment?
Yes, we talked about that. We
Because
talked
that, again,
about
was something the doctor said was that they did think that he acknowledged that he had a mental health problem, and that he would take medication. Have you had a chance to talk with him since the conviction about that aspect?
Yeah, we talked briefly at times about it. Like I said, a lot of it I try to keep him up, and some of that just brings him all the way down. But yeah, we have talked about it, and he understands he needs to.
All right. Do you think you would have any be able to have any influence over him in terms of his ability to take medication and to receive mental health treatment if that was what the doctors at DOC and later would tell him he needed?
Oh yes, oh yes.
Okay. And I'm sorry but normally I have to apologize just for women out about men, but how old are you?
I'm 56, so I'm soon be 57.
All right. Thank you, sir. Questions on the court's questions, Mr. Casanova?
Yes, Judge. Mr. Dorsey,
Right.
We did have discussions with you about talking to Elias about that.
Yes.
And he said, we're anxious, you were encouraging him to cooperate.
To cooperate at all chances, do what you're supposed to do.
And as a result of that encouragement, he was
Yes, he's been cooperating.
and that's all.
Questions on the court's questions, Dave?
No, you mentioned it.
All right, thank you, Mr. Dorsey.
All right.
You may call your minutes. Ma'am, could you raise your hand for me? Do you promise what you about how the court will be the truth, the whole truth, nothing but the truth, under pain and penalty of perjury?
I do.
Right, please have a seat. Once you're comfortable, can you tell me who you are and for our record, spell your name for us, please?
Excuse me. I'm Elizabeth Odle, spelled Elizabeth. Odle, Odle.
Thank you, ma'am.
Ms. Odle, could you explain to the court how you know Elias Dorsey?
I have known the Dorsey family and Elijah through his elementary attendance at Washington Urban IPS School 14, where I was principal during the entire time that he was there.
And are you currently retired?
I am currently retired from Indianapolis Public Schools, as well as other positions, but I left Indianapolis Public School in 2009.
And so when you were principal at IPS 14, did you also, Elias, did you know his younger brother, Deontay?
I knew the entire family. The entire family was highly respected. Then our school, individually and collectively, having a mother and a father to be in attendance at the school was always something as a leader of a school to be valued and appreciated. And so, yes, I knew the whole family. I knew all of them and helped to make sure that whatever I was doing as my position being the leader of the school, that I was also being the supporter of the family development.
And was there, when you were at IPS 14, was there a program you implemented called the WISH program?
Yeah, the WISH program was, the initials stood for Washington Urban School Helpers, and that was the parent organization for the school. This was an initiative that was started after I became principal, realizing that it's not up to the school and the school only to help in the development of our students. It is the parents, it's the community involved, as well as supporters. And so our parents at the school, which included Dorsey's, were one of the ones that helped to we didn't call it the PDA. It was not just a parent-teacher association. This was an association that was designed to support the school in whatever fashion and to support the activities of the students. And that is, since the school was named Washington Urban, that is why we call it the Washington Urban School Helpers.
And I think you said the Dorsey family was involved. Were they actively involved in the WISH?
Very much so. Very much so. The Dorsey's family was involved not only during the school day, but as Mr. Dorsey has already indicated in his sharing, they were involved in activities outside of the school as well. That was one of the things that, as a focus, that I, as an elementary school principal, believed that, again, the school was not the only place where a child had to grow up, but he had to grow up, they had to grow up within their community as well. So we tried to involve our kids in as many things as we possibly could. We tried to support them and make sure that they understood that we were preparing them for life.
And fair to say that you never taught Elias in a classroom?
Right. As the principal, I never taught him in a classroom, but as a principal, I tried to set standards and for all of my students, with him being included as far as what we should do inside as well as outside of the classroom.
Was there any ever, were there ever any incidents in which Elliahs would be sent to you as principal?
I do not have the recollection of any situations where he was sent to me for any discipline. And I do remember from conversations with my other teachers that whenever there were situations that would involve classroom or groups of students, I do remember that he was always a quiet person in the group. Even the way that he's looking now was typically the way that he would tend to be looking whenever I had my presence within the situation. And he would be one that I could always count on that might, if he said something, it was always a statement of, okay, guys, let's do what was asked of us. He was one who was respectful. One was counted on to at least make a statement that would at least bring things, or what I say, bring situations to a calming point if it was something that was not right at that point.
And you testified just earlier that basically you had information from other teachers who saw Elliahs in the classroom with regard to who he was. What you just described was the general reputation he had, not only with you, but also with all the other teachers.
I would say yes, it was the general representation. I did not and cannot recall any incidents that were directed to him being an issue that I had to just make some decisions about. Whatever. He was not one that I had as a problem child. And one of the things I also remember was that at School 14 we had a program that was sponsored by the Kiwanis. And it was a program where at the end of a period of time for this grading period, teachers would recommend students that they felt that exemplified the motto of the Kiwanis, which was called Terrific Kids. And each of the letters stood for an attribute. And forgive me for not necessarily remembering all of them, but I know the T was trustworthy. The E was maybe enthusiastic, and the R was respectful. And so those initials and all of those were the characteristics that teachers had to look for within the individual students. And I do remember that he was at one time selected by the teachers to be the terrific kid as representative.
And are you also familiar with some of these teachers, Chris Nichols and Bishop?
Right. Mr. Nichols was a long-time physical education teacher at the school. So he was the teacher that worked with students from kindergarten through 6th grade. And Miss Bishop was one of the intermediate level teachers, yes, that worked with him.
And based on your recollection of conversations with them with regard to Elliahs, did they also see him in the same way that you just described?
I would say that they shared the same sentiment. As a matter of fact, when the incident was publicized in the news, and School 14 still now has a collective group of teachers that are on Facebook, and we still stay in touch. It was deeply saddened by those that were commenting, even from those who did not have him in the classroom, but said, oh, I remember the parents. That was one of the things that they would say, is that I remember those parents. They were there all the time, before school and after school. And so, yes, it was never anyone who would say in our conversations that this was something that they might have thought. It was just, oh, wow, I can't believe this. I can't believe this. And so, yes, that was the sentiment that was shared. Personally, with my conversations with those two teachers, Mr. Nichols, who had him for every class, every grade level, for Miss Bishop that had him for the intermediate grades, and for some of the primary teachers that remembered his brothers too and would say, oh, not brothers because he only had one brother that attended the school, but yeah, there were those who just was their heart and passion for just thinking about the situation. It rang out in conversation.
And that kind of response of surprise was based on the fact that he was always, from what you could have seen, somebody who was even temperament.
He was always a very quiet, well-respected young man in and out of the classroom. He was one that I know Mr. Nichols' first comment was like, oh, I could always count on him, that if the group was not doing the right thing or if there was a substitute teacher or someone that was there. I remember Mr. Nichols' comment was that I could always say to him, what's going on? And he would be one that would honestly represent what was going on, but he also would be honest and saying to the other kids, come on, guys, let's straighten up. Let's do the right thing. And Mr. Nichols, that was one thing that Mr. Nichols, and I shouldn't be saying representing Mr. Nichols' words, but I'm just saying those were comments that Mr. Nichols shared to me, that he would always find that to be his character.
But that was generally his reputation.
Correct, yes.
I have no further questions.
You may cross.
Feel free to judge. Ma'am, when the defendant was at your school, what age range would he have been?
From my remembrance now, I would say that was grades 2nd through 6th grade. Now, our school changed from 6th grade to 5th grade at one time, so I was in all of that for the primary through the intermediate grades.
Thank you. No further questions.
You right? How long were you at IPS?
I was at IPS totally for 37 years,
How many of those years were you principal?
and I was principal at school 14 or 18.
Thank you very much for your service.
Yeah, it was quite a service.
You may step in.
Okay, thank you.
You may call your next. Raise your hand. You promise what you're about to tell the court will be the truth, the whole truth, nothing but the truth, under pain and penalty of perjury? Yes. Right, please have a seat. Comfortable in the chair, can you tell me who you are and begin for our records by your name?
Yes, I am Larry Dorsey Jr., Larrydorcey.
And Mr. Dorsey, can you remind the court again what your relationship is to Elias?
I'm his older brother.
And as well as Elias and your younger brother Deontay, did you also start playing football at a young age?
Yes.
Did you continue playing as long as Elias did?
No, I didn't play as long as they.
Were you also involved in assisting your father in coaching?
Off and on, yeah.
Would you say you were involved to the extent that Elias and Deontay?
No.
Of the three of you, who was most involved in assisting your father?
Elias.
Have you seen Elias in his involvement in coaching youth leagues?
Yeah. Yes, I have.
And what's your opinion in observing it? Well, first of all, how often have you seen that?
Whenever I could make it. If he had a game, if my dad had a game, I just sometimes show up. Sometimes I didn't.
And based on what you observed, what's your opinion of Elias in terms of his involvement with that coaching and his feelings towards that coaching?
Passionate, very passionate with it. He loved every bit of those kids, like it was his own if he had children. And he made sure they, like my dad, and said he was a mentor. He made sure he get his kids to and from practice. If he needed a sponsor with equipment, he would do what he can to help the kid out.
And I'm going to show you what's the mark identification of Defendant's Exhibit D.
Do you recognize that?
Yeah.
Do you recognize that as Elliahs with one of the kids that he coached?
Yes.
And is that a fair and accurate representation of Elliahs' involvement in coaching on that day?
Yes.
Okay. Move to admit in public.
Show D admitted without objection. And I'm showing you D. Can you describe a little bit the expression on Elias's face? Is that something you've seen before?
Oh yeah. Oh yeah. He had a Kool-Aid smile, I like to say. He was happy.
And is that something you have seen on a regular basis when he's involved in coaching?
Yeah. When they win.
I'm sorry?
When they win.
When
If they win, yeah.
Have you also seen the way the kids that he coached responded to him?
Yeah.
Can you describe a little bit about what you
Just somebody to look up to. Like he was a role model. He was so positive. As you can see, he always had that smile on him, and he could relate to the kids because he was easy to talk to, and he could put himself in some of those kids' shoes and just help them with any problems they had. If it was school, girls. Yeah.
I want to talk to you a little bit about some of the changes that you saw in Elliahs leading up to the incident. I think you testified at the trial that you did notice some changes in him.
Yes. Yes, sir.
And if I'm recapping your testimony, that involved him more regularly carrying a gun and wearing a bulletproof vest
Yes.
in situations that you didn't think that was necessary.
Correct. Yes.
And looking back on that now, I think you testified that you recognize those as some signals that you should have responded to in more of a better way.
Excuse me. Yes, I should be more aggressive with it.
But you did obviously make a number of phone calls that morning that day to try and address what was going on.
Correct. Yes.
Do you think you're in a better position right now to recognize those types of signs or symptoms than you may have been 4 years ago?
Yeah.
And have you been in regular contact with Elias since he's been at Newcastle?
I have.
Will you continue to have that kind of contact with him?
As long as the phone system allows it. Yes.
Okay. And just to be clear, how close were the two of you growing up together?
Pretty close. I mean, we was 5 years apart, but that was my baby brother. So
Would you be encouraging him, if you did notice these symptoms again, to receive or accept treatment?
absolutely.
Have you also had, now, can you tell the court who Tiandra Cox is?
That's my long-term girlfriend.
And how long has Tiandra known Elias?
As long as we've been together.
And give the court some idea of how long.
10 plus years.
How would you describe Tiandra's relationship with Elias?
Very close. They both was Geminis, and she would reason with them a lot. Like because she's easy to talk to, so he kind of gravitated towards her.
And from what you've observed of their relationship, is Tiandra somebody Elias needs?
Yes. It's his big sister.
And given the contact you've had with Elias since this incident, and your discussions with him about what happened, do you feel that Elias would listen to you in responding to your concerns about him getting treatment if he notices?
Yes.
Has Elias also expressed remorse to you about what occurred?
Yeah. Every time we talk.
Is that a regular, something that is regularly expressed when you have conversations with him?
Yeah. He has good days and he has bad days.
I don't believe I have any further questions.
You may cross. I've got a matter, thank you, sir. Thank you. You may call your next. Okay, raise your hand. Promise what you're about to tell the court will be the truth, the whole truth, nothing but the truth under pain of penalty of perjury.
Yes, Your Honor.
Please have a seat.
Will you remind the judge how you know Elias?
Let's get her name and spelling first, okay? Just so we've got it for the record. So don't blame, just for the record, just tell me who you are and how you spell your name.
I'm Tiandra Cox, Tiandra Cox, COX. I'm the longtime partner of Larry Dorsey Jr.
COX.
Yes, sir.
Okay, thank you.
And you're the longtime partner of Larry Dorsey
Jr.
And is that how you know Elias?
Yes.
And about how long have you known Elias?
Since he was a freshman in high school.
And I think you just heard Larry kind of refer to you as a big sister to Elias.
Yes.
Is it fair to say that you and Elias are close?
Yes, very.
And does he confide things in you that he doesn't necessarily confide in other people?
Yes.
And in the weeks leading up to this incident, were you becoming concerned about Elias?
Very much so.
And what made you concerned?
His behavioral changes. He did confide in me a lot of times about him being depressed. And as someone, I also suffer from depression, so I just recognize some signs of increasing mental health issues.
Now having kind of the clarity of hindsight and 4 years of education about mental illness, if you saw those same signs or he was saying kind of the same things, what would you do differently or what would you have the family do differently?
Early intervention is key. I probably would have rang the alarm sooner, pressed harder, and tried my best to educate others around me about some of the signs of worsening mental health.
I want to shift gears a little bit and talk about your sons. You have 2 sons, is that right?
Yes.
And what are their names and ages?
Andreas is 17 and Titan is 8.
And so Andreas, does he go by Dre?
I'm sorry.
Does Andreas go by Dre?
Yes, he goes by Dre.
What is Elias's relationship with the boys currently?
Uncle. That's their uncle.
Does he
Andreas, when he's at home, sometimes he'll hear Elias on the phone. He doesn't know where Elias is, but he just assumes he's away at school. So whenever he hears his voice, he gets excited and he'll say, "Hi." He's like, "Hey, Elias, what you doing?" My son has autism, so he doesn't really understand that. He just knows whenever he hears Elias on the phone, he gets excited.
So before Elias was incarcerated, how what was his relationship with the boys and specifically with Ray?
With Dre, extremely close. To the dismay of my sister and Deontay, Elias is Dre's favorite uncle out of all his aunts and uncles. He makes that well known. Um, Titan is he was still pretty young, um, but he says hey to him, but it's Dre. Dre is like Elias is one of Dre's favorite people.
And was Elias a positive person in Dre's life?
From the moment they met, he immediately when he met Dre was about 1 or 2. Um, he immediately accepted Dre as his nephew. And they've always had a bond that sometimes can't always form with others. Um, it almost he didn't even have to try that hard with Dre, and he bought a lot out of Dre. Um, and that's I'm talking about talking language, um, personality wise. Um,
Let me ask you this. Um, do you think Dre, I understand that Dre does understand where Elias is now.
no,
Do you think that Dre would benefit from having Elias physically back in his life at some point?
yes,
I want to talk to you a little bit about um, your conversations with Elias since he's been incarcerated. Has he shown or talked to you about any remorse he feels about what happened?
yes.
Can you tell us about that?
When I was first able to talk with him, he told me that he doesn't know if he'll be able to live with himself, and sometimes I ask him sometimes um, one day, will he be able to like forgive himself? And sometimes he says no, and yeah, I'm sorry. I'm sorry.
Take your time. Get Kleenex right in front of you. Help yourself. Need some water.
I'm sorry. Yes. Yes. And I just asked him, maybe one day he'll be able to forgive himself. And I just want him to be okay.
Do you want him to get treatment
He needs it.
And do you think that he now recognizes that he needs it?
Absolutely. I would ask him, do you think you maybe need to talk to somebody? He said, yeah, but it just never got he never got the chance to. And because of him, I got a therapist.
So you've known Elias about half of his life. Based on everything you know about him, do you think that he follow any rules that the court sets for him or that probation would tell him to do?
I have no doubt
And why do you say that?
because he's always been the type of person to always follow what he needed to follow. He was always somebody of his true to his word. So I never had any problem trusting him or thinking he couldn't do anything. He could always do what he needed to do.
Is there anything else that you think the judge should know before he imposes a sentence?
This is just that he's we're here. Um, my son is always be here, and he is loved, and he is remorseful, and I hope one day Drake can see him again.
You across? Do you think he's suicidal?
At one point,
Okay. Help me out. When do you think he was? And do you think he is now?
it comes and goes. Um, I haven't heard him talk about that in probably a few months, but I know right after he got incarcerated, um, he was expressing despair and that he didn't want to live anymore.
Okay. How recently do you think that he would have been suicidal?
It was
Have you talked to him since the trial?
probably about. It's been a while, probably about 6 months, maybe.
Okay. All right. That's the last time you would have thought that he would have been.
That's the last
Or
time
is that the last time you talked to him?
last time I talked to him about that, about possibly being suicidal.
Okay. But you've had frequent discussions with him about that?
Yes.
Okay. Anything else you want to tell me about that?
I told him that sometimes that I used to think about that too. So we kind of bond in that way. I have clinical depression, so I kind of know what he's talking about.
Mhm.
So
And
I told him,
Did I hear you correctly that you have been getting treatment as well?
yes,
Yeah, good.
yes,
All
sir.
right, that's good. Okay. And I didn't mean to cut you off.
That's okay. And he has somebody that knows the system and is actually getting help. So I'll be there to support him any way I can.
All right, thank you. Questions on the court questions? Vince? Steve? Good. All right, ma'am. Thank you very much for coming
Thank
in.
you.
You may call your next.
Name is spelled D-A-N-T-E, Dorsey, D-O-R-S-E-Y. I'm the younger brother of Elliahs.
Thank you, Judge. Deontay, you already testified during the trial. In terms of age, how close are you to Elliahs?
I'm a year and a half younger than him. So.
And growing up, did you two of you attend IPS school together?
Yes, we did.
And basically, you also attended Arlington.
Yes.
I think there was a period of time when Elliahs was held back 1 year.
It was in middle school. I think his 7th or 8th grade year. So at that point, we evened out.
But from that point on, the two of you basically were in the same grade together through middle and high school.
Yes.
And would you say that because of that, you saw Elliahs on a more regular basis than your older brother?
Oh, yeah. Seen him a lot more. We did everything together. So we went to school together, played football together, all the extracurriculars we did together. So.
And understanding that, your brother Larry is close to Elliahs as well, but would you describe yourself as close?
Yeah, I think I'm closer to Elliahs than my brother, older brother.
And you played football all through high school with Elliahs?
Yes.
And then also played in college as well?
Yes, I did.
Were you also the valedictorian of your high school class?
Yes, I was.
And where did you attend college?
Undergraduate.
Yes.
Manchester University.
And what was your major?
I majored in criminal justice and minor in psychology.
And did you also just recently get an advanced degree?
Yes, in 2022.
And where did you get your advanced degree from?
Indiana Wesleyan University, master's in social work.
And are you currently working in that capacity as somebody who has a master in social work?
Yes, I'm with the Department of Veteran Affairs. My title is collaborative care manager, but it's a social work position.
And based upon that advanced degree in social work and also your minor in psychology, I'm assuming that you had both classroom and practical training in dealing with mental health issues.
Yes.
Could you explain to the court a little bit about
My current position, I do measurement-based care for veterans. So I ask them questions such as the PHQ-9, which is depression screener, the GAD-7, which is anxiety, the PCL-5, which is the PTSD. We go through CSSRS, which is the Columbia suicide screener, and also things like ISI, the insomnia, and the psychosis screener. Whenever a veteran is positive for those things, they get transferred to me or another coworker to complete. It's called a comprehensive suicide risk evaluation, the CSRE, and then we go through the details of basically the whole gamut of thoughts, plan, action, treatment, and also if they have psychosis, we ask those questions like, what do you hear, what do you see, do you recognize what they see, and like how you feel, and things along that line.
So basically, you're training both in the classroom and your practical training now with an advanced degree related to identifying and helping people deal with mental health issues.
Yes, and I'm going to start supervision and hopefully sit for my clinical social work in 2 years, so I'm going to receive that supervision also.
And your advanced degree, you obtained your advanced degree subsequent or after this incident, is that?
Yeah, I started in January 2020. So, and obviously COVID hit, so it took a setback. But I didn't have any type of training to recognize these things prior to that, because this happened in March or April 2020. So.
And I think you did testify at trial that you did notice changes in Elliahs leading up to the incident. Do you feel that you're in a better position now, based upon the more extensive training you've had, both in the classroom and practically, to recognize and address those issues if they arose again?
Oh yeah. For example, I still go back through the text messages, and I can see now that he was asking for help. He was saying he was stuck, having those feelings of hopelessness, if I knew what I knew now, I would have did basically like almost crisis intervention. I would talk to him, challenge his negative thoughts, get help if needed, like seek inpatient treatment, and like talk to somebody.
And I'm assuming that as a social worker, you had some familiarity with terms like risk factors and some training in recognizing what risk factors may be in a particular case,
Yes.
and also what protective factors.
Yes.
And in your training, is family support considered to be?
It's a big protective factors. That's one of the things I ask veterans when they say they don't have anybody. Well, I ask them, "Do you have family?" "Yeah, I have my daughter I look out for. I have my mom I take care of. I have my brothers I talk to, or even the dog they take care of." Those are all protective factors.
So, for example, when Keandra was here talking about Elias's relationship with Dre, that type of relationship and closeness would be considered a protective factor.
Yes, it is.
And fair to say you and your family have had a lot of conversations about Elias since he's in school.
Yes.
Did you have conversations about how you, as a family, may continue to support him, for example,
If he was,
convicted?
yeah, we just continue to talk to him, support him in any way we need, anything necessary for him.
And is that basically consistent with the relationship that has existed in your family throughout your life?
Yes, if one of us need help, we step up and help.
And I just want to talk a little bit and give the court a sense of your, in particular, your closeness to Elias. Well, first of all, let me back up. Your father, you were in the courtroom when your father testified.
Was I in the courtroom?
This morning.
Oh, this one, yes.
And he described the things that he did to keep you and your other brothers out of trouble.
Yes.
And would you agree that given some of the neighborhoods you grew up in, that was critical in helping you and your other brothers avoid being arrested?
Oh, it's very critical. Yeah, it's very critical. Kept us out of trouble, kept our head straight, kept us busy.
And I'm assuming that that's something that you continue to demonstrate in your relationship with your children as well.
Oh, yes. Once they are aged, they're going to be in some type of extracurricular of their choosing, obviously.
And you continue to do that with Elias as he moves forward.
Yes.
Were you as involved in coaching as in youth leagues as Elias was?
Not as extensively. He had his own, like as soon as he was almost eligible, he had his own team he was managing. I think it was a 5 and 6 year olds. So he was over that whole age group where I was just occasionally help out with bouncing from team to team, helping with the offensive line and defensive line.
And Corey testified about that you and Elias played football together. I'm going to show you his mark for identification as defendant's B.
Do you recognize that?
Yes.
And what do you recognize that as?
It was after our middle school championship game.
Okay. And you and Elias were starters on that football team?
Yes.
I move to admit defendant's E.
So he admitted without objection.
And I'm showing the inset there is that basically you, Elias, and your mother, Bob.
Yes.
And that would be typical of the kind of support that your family has always shown both to you, Elias, and your older brother.
Yes, they try to make it to every game, even in college.
And then you talked about that you and Elias attended Arlington together as well.
Yes.
I'm going to show you some mark for identification of defendant's F.
Do you recognize defendant's F?
Yes, that's our prom picture.
Is that your prom picture from Arlington?
Yes, from Arlington.
Okay. Is that a fair and accurate representation?
It is.
Move to admit F.
We should F admitted
17 or 18.
Um, when, and then let me also show you what I'm now marking for identification of defense chief.
Do you recognize G?
Yes, that's our varsity letter.
Uh,
It's in pen like COD. That's Elias's. 'Cause he got the baseball. He was part of the homecoming court. Also Chevron.
Okay. Move to admit defendants G.
Should G admitted without objection? Waive coverage.
And Deontay, just showing you G, just ask you a couple of questions about the letter there. There's a pin there, CLD. What does that stand for?
Center for Leadership Development.
Can you explain to the court a little bit what's involved in the Center for Leadership Development?
So that's a program. I think we attended our junior or senior year of high school, where they gather basically eligible, identified leaders of the high school from different high schools around the city, and they go to an off-site location, I think twice a week, and learn leadership skills, and like basically developing the leaders for tomorrow.
And will both you and Elias part of that program?
Yes.
And you and Elias attended Arlington. Were there a lot of students from Arlington involved in that program?
No, there's only about, I want to say 5 or 6 of us.
And then I'm going to show you what's the mark for identification as defendants H.
Do you recognize that?
Oh yes, that's our second year at United Water internship for summer 2012.
And is that a fair and accurate representation of that photo, of that incident when the photo was taken?
Yes.
Move to admit H.
We show H admitted without objection. Deontay, I'm now showing you H. Can you explain to the court a little bit what this internship program is about?
So it's the United Water internship. Prior to 2012, it was only open internal to Arlington students, which Elias were the only juniors accepted to the program at that time. And the following year, which is when this photo was taken, it was open to high school students across the city. So that was open, and you had to be, I think, part of CLD to be considered for this internship. And me and Elias were only 2 students welcome back to complete this internship again in summer 2012.
And that's a touchscreen. Can you indicate on that photo where you and Elias are standing?
Okay, first circle is Elias. Oh, and God, I can't draw a circle, but that's me.
And was Bianca Davis also part of that internship program?
Yes, she was.
Is she depicted in the photo as well?
Yes, in the bright pink jacket.
After you graduated from high school, you went to Manchester, correct?
Yes.
And would that have been the first time that you and Elias had really been separated?
Yes, it was.
And based upon everything the two of you had done together, what you know of Elias's relationship with you and how close the two of you were, in your opinion, would that separation have been difficult for Elias?
Yes, it was. Especially, I think after high school, had the opportunity to go and keep playing football, and he had to take a year or 2 off. So even seeing that was kind of hit you in a soft spot, hard spot in your gut. It's like a gut punch. Like I played football with this person from 5 until high school. Now you still playing and I'm not.
And did you two continue to remain in contact, but just not quite as much as you had?
Yeah, not as quite as much, but we still had contact.
And during this time where you were at Manchester, and there were a couple of years where Elias was still trying to get to college, to your knowledge, was he still regularly working?
To my knowledge, yes.
And up to this incident, to which you knew, was he always regularly working?
Yes.
Have you
quite frequently.
And you're married, correct?
Yes, I am.
How many children do you have?
I have 2.
What are their names?
Jaden, he is 3, and Roman, he is 8 months now today.
So Roman was born just in the middle of last year.
Yes, August 4th.
In your conversations with Elias since he's been at Newcastle recently, has he expressed interest and concern about your kids?
Oh yeah, he always want to have a chance to talk to Jaden or see pictures of Roman. He wants to be involved. I always say he's a better uncle than I am. So.
And again, going back to what we talked about in your training, both practically and academically, would that type of relationship be considered protected factor?
Yes.
So, based upon what you know, in your opinion, does Elias have a significant amount of protective factors in place with regard to his relationship with you, your older brother Larry, Deandra, his relationship with his mom and his dad, and also his relationship with Larry Jr.'s children?
Oh yes, and even my wife.
And your wife as well. And I think you testified earlier that you are more attuned to noticing any of these symptoms that you saw prior to the incident.
Yes.
Has Elias expressed to you, well, in your opinion, from talking to him, do you think Elias recognizes that he was going through some type of mental illness at the time of this incident?
I believe now he does, but at the time he probably didn't know.
Do you think that based upon the type of regular contact that you've had with him, continue to have with him, that he's in a position now where he would be accepting and he would cooperate?
Oh yes.
And would you be sure to encourage him if there were any issues?
Oh, most definitely. I will make sure that he receives some type of treatment, whether that be therapeutic interventions or medication compliance, anything along those lines.
Just finally, what you described as a very close family. Does your father in particular have a good deal of influence over not only you but Elias?
Oh yes. Take his word very seriously.
And that's something I'm assuming you learned from your father and would continue to exert with regard to Elias.
Absolutely.
Has Elias expressed remorse to you?
Oh yes, yes. He often, when we speak, say he's real sorry that it happened. He expressed remorse for the family. He feel like that he failed us, himself, the community.
Do you feel that at this point Elias is suicidal?
At this point, no. In the past, he have made comments that he don't think he can make it. He don't want to be here, like fleeting thoughts.
And were those thoughts that were kind of common, particularly when he was facing the death penalty?
Yes.
Were you aware of how your father, in particular, and you and your older brothers responded when he expressed to you that he just wanted to give up when he was facing death?
Yeah, I talked to my brother and my dad about it. They try to keep him hopeful, positive, and even I try to take his mind off of it and try to educate him a little bit. Like it's almost how I think of suicidal thoughts. It's on the curve. It's always going to be there, but at some point it get high, acute, and it just goes back down. But those thoughts are always there, but you got to manage it.
And based upon the influence that really your father and you and your brother had on Elias, did that kind of make him want to continue
or would be most responsible for monitoring and taking care of his mental health as he gets older?
Oh, yes.
Are there, if you had to choose another person, and for some reason you got a job and you went to Alaska or some other place, hypothetically, would there be another member that you would recommend that if you weren't able to do that, that they would be in a position to do that?
Oh, my brother.
Okay, which brother?
Oh, Larry.
Larry, I'm sorry. Okay, questions on the court's questions, defense?
But also understand your father is in his 50s now. He is, would you agree that he is definitely somebody who would also be available?
Oh, yes, he would be the primary person, my father. But I was thinking in terms of if something would happen.
Which was the point of my question.
That's why. And also, just to point out, my wife is also a social worker, so we're both in a position to monitor his mental health.
Steve?
Sir, where do you live?
I live in Jeffersonville, Indiana.
And how far away is that?
100 miles.
Nothing further, Judge.
Mr. Castello?
Both your brother Larry and your father both lived here.
Yes, they are.
And is it fair to say that your family has been very interested in having a face-to-face visit with Elias?
Oh, yes.
Given the conditions at Newcastle, have you been able to get that done?
No, only through their spotting video systems.
But obviously that's something that you and your family are very eager to have.
Yep, as soon as we're able.
Nothing further on that, Judge.
Steve?
Nothing on that, Judge. Thank you.
All right, thank you very much. All right, lawyers, we've been at this for about 90 minutes. Good time for us to take a bathroom break. We'll be in I see 11:03, 11:04. We'll be back at 11:17. All right. 12:30 then, because I'm not gonna take more than an hour for lunch.
Okay.
So you're out of witnesses at this point?
Yes.
Okay. And Steve, do you have witnesses scheduled as well?
We do.
If you want to get everything in today. So, any reason to think that we can't do that?
No, we will be able to get everything into the stage. I don't see any issue with that.
Judge, we have several who are prepared to make victim impact statements, and I guess if we want to move to that portion now, we can do that.
I'm sorry?
We can move to that portion now, I guess, if the defense is prepared with witnesses. So.
It doesn't matter to me, or whether we just take a lunch break now, when we come back at 12:30, it doesn't matter.
I'm fine if we just want to take a lunch now and then.
Okay. Do we, since we do have a little bit of extra time, and I know that I talked to the lawyers by email before, did you want to discuss the count 6, the criminal confinement and the merger issue?
Sure.
Okay. Because the court's general impression is that there is merger on the weapon portion, reducing the level 3 felony down to a level 6. I believe the defense indicated you thought that it totally merged, and I think the state believes it doesn't merge at all. So you still have those same positions, or have you done some research on it since?
After researching it, I am more entrenched on that position than I was before.
Okay. Well, we have time, so let's hear it now. Okay? So, Mr. Casanova, do you believe that there's total merger here?
Judge, Ms. Martin has made that argument before.
Okay. Ms. Martin, do you believe there's total merger here?
Yes, Your Honor.
Okay. All right, so I don't care which one of you goes first. Ms. Martin, you want to, since the defense has already had the floor on this, you want to go ahead and address that issue?
Yes, Your Honor. If you look at Waddle, and I'll address in a moment that Waddle was actually decided after these events, so there's an argument for a pre-Waddle too. But looking at Waddle, if a single criminal act or transaction violates multiple statutes with common elements, there's a substantive double jeopardy issue. And so, first we have to see whether the offense is an inherently included offense or a factually included offense. The criminal confinement with a deadly weapon, Aisha Brown, is an included offense of attempt murder because the criminal confinement with a deadly weapon, he shot her, preventing her from making it down the stairs, confining her to the apartment so that she could not get out to get help, or he thought to, get some assassin.
This is the confinement. What happened during the course of the evening before the shots were ever fired, before the police were ever called?
Well, Your Honor, it's just the way it is charged is that he
I don't think they specified that it was just the generic confinement against her without her consent.
Yes, it's just charged as knowingly or intentionally confining AB without the consent of AB, and Elliahs Dorsey being armed with a deadly weapon, to wit, a firearm. So your question is a great example that there's some ambiguity. Is the confinement when he shot her so she couldn't get out, or is it when he held her back before shooting? I think he said that he placed his arm in front of her. Is it some other time? the jury may have had different ideas of when that confinement happened. And so because of that ambiguity, I think we have to resolve any ambiguity on the part of the defendant. And so that same transaction of shooting her to prevent her from going downstairs could have been what the jury thought was the confinement. It's also the attempt murder. And so the counts are established by proof of the same material elements. And the criminal confinement differs from the attempt murder because of a lesser culpability. The confinement was a knowing or intentional culpability. The attempt murder was a specific intention to kill. And because of the ambiguity, the criminal confinement is factually included in the attempt murder. Also, whether it's, initially just kind of holding her back as he's shooting, or immediately afterwards when she runs out and he shoots her in the landing area, that is one continuous crime that is so compressed in terms of time, place, singleness of purpose, and continuity of action as to constitute a single transaction. We argue that the confinement would have been when he prevented her from running downstairs to get help, but all of that was one quick action. And I think the officers testified at trial that even as they were going downstairs to get out, they heard a second set of volleys. So it was a volley of shots. So it was right after those initial shots that went through the door. And so all of that happened in a very quick time span. I think the officers testified at trial somewhere between 30 seconds and a couple minutes of the whole thing. And so, therefore, we think that based on Waddle, there is a complete double jeopardy issue. Pre-Waddle, we would agree with the court that it would at least be a level 6 criminal confinement because of the common element of the firearm with the confinement and the firearm as part of the attempt murder. So pre-Waddle, it would be a level 6.
Okay, so if you concede pre-Waddle, and since it was pre-Waddle, is there anything in the case law after Waddle this would be applied retroactively?
So the case law that I have found has applied pre-Waddle retroactively, and in those cases, it benefited the defendant. But in the case of Cameron Banks and Desmond Banks that occurred in February of 2020, so along these same timelines, but were just recently decided that the court reduced the level 2 robberies to level 5 robbery, one robbery, because they occurred pre-Waddle.
Okay, and you're going to give me those sites?
Yes, I can. One, I know Cameron Banks doesn't have a site yet because it's so new, but I will send you.
Is that, I guess I'm most interested in the case is that you believe that Waddle has been applied retroactively.
That's Cameron Banks with Desmond Banks. I will see if Desmond Banks has a side. Cameron Banks, I can give you the appellate number, but it was just decided March 15th.
Okay. And it was a Court of Appeals as opposed to the Supreme Court?
It was Court of Appeals.
Okay. All right, I can probably find that on the computer. So it's Banks, B-A-K-S?
Yes.
Okay. And in that case, was that specifically the issue? One of the issues that was specifically argued was the retroactivity of the law?
Yes, that was issue 4.
Okay. All right. Anything else, Ms. Martin?
No, Your Honor.
All right. Give me just a second, State, so I can get my notes right here. All right, Steve?
Thank you, Judge. Fortunately, this issue is clarified by AWV State, which was just announced by the Supreme Court last month, where the court articulated the most recent scheme for evaluating a double jeopardy claim. And from what I just heard from the defense,
Give me a tight on that one.
yeah, it is AWV State. It's so new, all I have is 2024 Lexus 154 at page 13.
And that's, you say it's Supreme Court?
Supreme Court from just last month.
Yeah, you have dated decision.
I do. It was March 12th, 2020. March 12th, 2024.
Okay. All right, go ahead.
And from what I just heard from the defense, at no point did they engage with the analysis that AW sets forth. The first question before we look at any evidence is whether we are talking about included offenses for double jeopardy purposes. So there is a statute that the court directs us to first. It's Indiana Code 35-31.5-2-168. And it says included offense is an offense that, now, two of them don't apply here. It's either if it consists of an attempt or a conspiracy to commit. Obviously, that's not in play here. Or if it differs from the offense charged only in respect that's a less serious harm or risk of harm. We're not dealing with that. The pertinent part of that statute says that an included offense is an offense that is established by proof of the same material elements or less than all the material elements required to establish the commission of the offense charged. So AW then directs us to look at the offenses as charged. Count 2, attempted murder, states that Elliahs Dorsey did attempt to commit the crime of murder, which is to knowingly and intentionally kill another human being, he being Aisha Brown, by engaging in conduct that is shooting a firearm at Aisha Brown with a specific intent to kill Aisha Brown, which step constituted a substantial step towards the commission of murder. The confinement charge states that Elliahs Dorsey did knowingly or intentionally confine Aisha Brown without the consent of Aisha Brown while being armed with a deadly weapon. So if we look at those offenses as charged, there is no argument that the confinement is inherently included in the attempted murder. We have two totally separate burdens for proving the confinement in the attempted murder. The case law in Walker used the phrase as charged or factually included when deciding if an offense is included. But basically what that means is that the charging instrument alleges the means used to commit one crime are the same means or include all of the same elements used to commit the second crime. And here we just don't have that. The attempted murder consists of an actual attempt to commit a crime of murder. The confinement is to knowingly confine somebody against their will, here with the additional element of a gun. The offense, or the elements needed to prove the confinement, as charged as a level 3, are not sufficient on their own to prove the attempted murder. And as the court describes in AW, if the offenses are not actually included, That is the end of the court's analysis. Full stop. Now, even if we do go a step further under the old Richardson test, which has been abrogated and overruled several times by the Supreme Court, even if we look at the actual evidence, there is no overlapping evidence as presented in the charging information and at trial to presume a double jeopardy violation. As charged, as argued, Elliahs Dorsey confined Aisha Brown in the apartment with a gun. The argument was very clear. The facts presented from Aisha Brown's testimony was that she went to go answer the door. She went to leave. He kept her in the apartment. While he was doing that, he is holding a gun. None of the evidence.
So you're agreeing that the confinement then is within the short period of time of the police knocking on the door, the defendant shooting the weapon, and then the immediate responses that go from there to the point of Alicia being shot as airwell. It's all of that time compression.
No, shooting the weapon has nothing to do with confinement. Shooting the weapon out in the hallway is a separate offense. The confinement is when he prevents her from leaving the apartment. That is the commission of that offense. The attempted murder occurs after she escapes the confinement. They can't factually be related because the reason he shoots her is because she flees. And that is not part of the double jeopardy analysis. If we had charged him with unlawfully carrying a firearm and also confinement armed with a firearm, I completely agree that the unlawful carrying, because the only element needed to prove that is that he carried a gun, would be subsumed in the confinement charge, in the attempted murder. Because the only element that we would need to prove would be that he carried a gun. Here, that's not what we need to prove. We need to prove that he confined her while armed with a gun. We need to prove that he tried to kill her.
With the same gun.
But under AW, the fact that the same gun is used in multiple crimes does not invoke substantive double jeopardy. There's a case that is exactly on point with this. It's Mendenhall v. State. It says there's no double jeopardy merely because the same weapon was used for both crimes. The crimes in that case were attempted murder and criminal confinement.
Give me the sign.
Sure. That is Mendenhall v. State, 963 Northeast 2nd, 553. That's page 572.
553.
963 553.
Second.
Yep.
Okay.
And in that case, disgruntled individual here kidnapped the Indianapolis attorney, held him at gunpoint in a vehicle that was armed criminal confinement, the court found. While he was still confined, the defendant picked up a gun, put it to the attorney's head, and pulled the trigger, and but for a malfunction of the gun, intended to shoot him in the head. The court said, just because you have the repeated use of a weapon to commit multiple separate crimes does not mean that it's the very same behavior precluding conviction on both offenses.
In that case, what was the time frame from the time? I mean, was the attempt of putting the gun to the head and pulling the trigger, was that within a short time period of the defendant or the victim being in the car with the defendant?
It was while he was still being confined, and the court found that there was no issue with the same gun being used to enhance the confinement, because the gun in and of itself was not an element of the attempted murder. It's just he has the intent to kill, or the intent to kill, specific intent to kill, and take some action to act on that. So in Mendenhall, there's no double jeopardy violation where the victim is being confined, a gun is put to his head, and the defendant tries to murder him. Here, we have a confinement with a gun when the defendant keeps Aisha inside of the apartment. He then commits 4 separate intervening offenses where he kills Breann Leath, and he has been convicted of committing criminal recklessness against 3 officers in the hallway. Aisha Brown then flees the apartment. At that point, she has escaped the confinement. The confinement is done. And then he shoots her in the back as she flees. So I understand we are talking about a short time period here, but we are talking about 5 separate criminal offenses that each have distinct elements, that have distinct burdens of proof on the state, and which were proven to a jury beyond a reasonable doubt by separate sets of evidence.
Anything else?
No, Judge.
All right. State any defense in order
we don't know what was proven beyond a reasonable doubt to the jury. They may believe that the confinement is what we believe it was, the shooting in the stairway to prevent her from leaving, therefore confining her to that landing. Maybe 2 of them thought that, maybe 3 of them thought there was a different confinement.
I'm sorry, what evidence was there at all that in the stairwell, the defendant laid hands or did anything to keep Aisha Brown down after he shot her?
He shot her in the stairwell. That's
And
with
then-
a firearm.
All right, and then didn't he go down and maybe have some brief conversation with her?
Yes.
While she was laying on the ground?
Yes.
Okay. I don't recall there being any evidence of any physical contact between the 2 of them.
No. When she was going out and going down, he shot her. He confined her by shooting her. It's just did confine her with a firearm. He confined her by shooting her, which prevented her from going downstairs to get help.
So under that logic, every time you shoot somebody, it's a confinement?
It could be if it's charged as blandly as this. We don't know what the jury was thinking. Maybe they think that is a confinement. Maybe they think it was in the apartment immediately before the shots rang out. If there's that ambiguity, maybe we didn't have a unanimous verdict on that particular charge, and I think that is resolved by vacating the conviction for the criminal confinement. And I will say that AW, all of those crimes, or that crime having a gun, a machine gun, was post-WAP, and so it does not have any of the pre-Waddle thinking or reasoning.
Did you encounter the Mendenhall case that the state's referred to?
I just pulled it up.
Okay. Well, I'm not asking you to comment on it if you haven't read it. You can do that after lunch if you want to supplement the record.
Okay.
Okay. Anything further?
No, Your Honor.
No, Judge.
Okay. Well, we're 11:55, so we were going to have to argue this issue anyway, so we've taken care of it. Don't have to do it in the afternoon. So we'll be in recess until the witness be here 1 o'clock.
Yes, Judge.
All right, so we'll continue then sentencing hearing with defendant's evidence beginning at 1 o'clock. Be in lunch.